is MS patient which has suffered a severe implication of the disease at the age of 45. It all started from a substantial numbness in her left ribs and right leg. She later has appointed her treatment with Dr. Kevin, which an independent consultant at SMX Nilai Medical Center. And the first consultation with him has brought to a diagnosis that she suffered a second progressive MS. However, he did not take any further action by referring her to any specialist. The damage developed after her transfer to Sandakan. She suffered neurological side effect and bladder cancer. And after several months, the implication became more serious until she has to give up her work. My lord, the Civil Law Act 1959, the Civil Law Act 1956 and Medical Act 1971 has stated that a medical practitioner who is liable for professional negligence is responsible for the damages that has been suffered by other party. With regards to the first issue, we argue that the respondent is liable for his professional negligence. To deal with the professional negligence that the respondent has committed, I will divide my submission into two grounds. First, I will argue that Dr. Kevin has done careless act as a medical practitioner as he is delaying any referral to the medical expertise. And second, I will argue that Dr. Kevin's act on delaying the referral has caused the appellant to suffer damages that affect her future earning. I will be presenting on the subground of the chain of causation occur after Dr. Kevin's act for not making any referral to the medical expertise. My lord, before I proceed to my submission proper, is there any preliminary question?
You may proceed.
Much obliged. My lord, with regards to the first issue, we submit that Dr. Kevin has done careless act as a medical practitioner, as he is delaying any referral to the medical expertise since he has failed to fulfill his duty as a doctor. According to the Section 28 of the Medical Act, a fully registered medical practitioner is considered a legally qualified doctor in Malaysia, and a doctor is closely to the neighbor principle. In the case of Donahue and Stevenson, Lord Atkin has defined the neighbor as the person who is directly affected by another person who has responsibility toward him. Dr. Kevin is a legally qualified medical practitioner. He works as a medical consultant at SMX Nilai Medical Center. Thus, he was expected to possess a particular level of knowledge and skill for the medical treatment. On the part of the neighbor term, it has clearly proven that my client has stated Dr. Kevin as her regular doctor. It can be considered that she followed all the advice from him during the consultation. Next, yes.
Dr. Kevin is an independent medical consultant, right?
Indeed.
Instead of so, is he attached to the hospital, or what does it mean by independent?
Much obliged, my lord. Can I have a moment for answering this question? Much obliged.
So the question rather, is he employed under the hospital?
My lord, as I can define that medical consultant can be meant as an individual to whom one refers for expert advice or service, and the use of the consultant is common in medicine. Thus, I would say that Dr. Kevin has been working under the SMX Nilai Medical Center. Am I addressing your concern, my lord?
So you're saying that he's not attached to the medical center?
I will say that he is attached.
Okay, all right. Proceed.
Much obliged. From this principle, it is proven that Dr. Kevin has breached the duty to disclose. He has diagnosed Amrita developing secondary progressive MS based on available medical evidence. However, under the Bolam test and Roger and Whittaker test, he he did not make any reasonable professional doctor will do. A professional doctor will make an immediate referral to the medical expert to confirm his diagnosis. He also failed one on the risk of the disease and the treatment risk. The case of Bolam and Fion Hospital Management Committee and Rogers and Whittaker has become the standard of duty for the principle of medical negligence. A doctor must be three standards of duty of care, which is the duty to diagnose, the duty to treat, and the duty to disclose. And breaching this duty can prove a doctor liable for negligence and responsible for the damage. Dr. Kevin X was similar to the case of Dr. Hari Krishnan and another, and Megat Nur Ishaq and another, which happened in 2018 at the federal court. The appellant have not warned the respondent of the risk of barking and blindness, which resulted him to lose his vision. And the judge later decided that they are liable for breaching their duty to warn and has been considered as negligent. Dr. Kevin should exercise his duty of care, which can be seen in the case of Elizabeth Chul at Government of Malaysia and another, which was held in 1970. The federal court decided that the anesthetist is not liable for negligence as he does exercise his duty of care. And the judge also said that the doctor were responsible for giving reasonable care and skill to the patient, corresponding with their knowledge and expertise. Referring to the case, Dr. Kevin should apply his knowledge on how to consult with the patient with rare disease. Upon giving the diagnosis, Amrita is entitled to have the explanation regarding her condition based on diagnosis. In this situation, Dr. Kevin did not warn her of the risk of MS and continue to give regular kind of treatment as he is treating someone with normal fever. This proves that Dr. Kevin has failed to exercise duty of care toward her, and he also is not a specialist in MS, so it's a must for him to refer to the MS specialist, and not doing so makes him liable for negligence. My lord, my ladies, before I proceed to the second argument, does the court have any question?
Please proceed.
Much obliged. Having finished with the first argument, I will now turn to the following argument concerning Dr. Kevin's act on delaying the referral. We submit that Dr. Kevin's act on delaying the referral has caused the appellant to suffer damage that affect her future earning. I will divide to one subground, which the chain of causation after Dr. Kevin's act for not making any referral to the medical expertise. Causation can be defined as an injury or harm that the plaintiff has suffered after the respondent has breached his duty. It can be measured by the cause, in fact, and the legal cost. My apologies. And the cause, in fact, can be determined from the but-for test, while the legal cost can be determined if the damage is foreseeable. In the case of Vincent Manikam, S.O. David, and Dr. S. Hari Raja, held in 2018 in Court of Appeal, the appellant has accused the respondent of causing her wife's death because of the doctor negligence. She has been undergone surgery and discharged after 4 days, and 5 days later, she admitted to ward with the same complaint, and after several days, she has died in the hospital. Therefore, the judge held that the respondent was liable for negligence because he did not fulfill his duty of care because of improper examination and treatment. Applying from this case, Dr. Kevin has failed to take any reasonable step to prevent severe injuries to my client who has been under his care. Amrita did not go to any hospital before transferring to Sandakan because she believes on the credibility of Dr. Kevin. So the diagnosis given by Dr. Kevin has been fully believed by Amrita. Thus, Dr. Kevin should have been followed up with Amrita's condition if he decided not to make the confirmation of the referral. Next, it is crucial to have medical expert support as part of evidence. This can be seen in the case of Perimalu anak lelaki Virapan and Dr. Amarjit Kau and others, which held in the High Court in 2001. It is shown that medical expert helped to prove that there was a probability that the doctor has not taken a professional duty of care toward his patient. It's also used on establishing the causation that happened because of doctor negligence. Therefore, my lord, the evidence that Dr. Azran has provided confirmed that the Dr. Kevin has caused the remoteness of damage, since he was not referring Amrita or the diagnosis to the MS specialist. If he did an immediate referral, she will have a remission of chance of remission for approximately 40% and the chance of survival for 10 years. And the delay referral has proven that he lowers the probability to 25% only. Next, the causation in law can be seen if the reasonably foreseeable that a respondent conduct will cause some degree of damages to the appellant. The Wagamount case in 1961 showed that a person is liable if he, a reasonable man, could foresee the damages that will occur. As a medical practitioner, Dr. Kevin should have general knowledge on MS and also its risk. A professional and a reasonable man could foresee that the delay of the treatment of MS can cause other effects such as bladder cancer and brain damage. However, he did not make any referral or the diagnosis to the MS specialist for further treatment. Damages can be assessed if the appellant life expectation has been reduced by the injury, considering the suffering and the pain. And in addition, a person shall be awarded for the damages if he not attained the age of 55 years and above and receiving earnings by her own labor. These have been referred to the section 28A to B and section 28A to C1 of the Civil Law Act. The case of Chan Yang Kiat and Liang Ziqiang and another was an appeal case from Session Court in 2012, where the appellant has a motorcycle accident. He suffered a total loss of his future earnings due to the accident. However, the High Court has allowing his appeal because he was eligible for the damage, but the judge considered that his suffering as a partial loss of future earning. This is because he is still considered can be employed after the accident, but with a lower salary. Unlike the recent case, Amrita has suffered from giving up her work and losing all her future earnings because of the effect of MS ever since the relapse. She is a 45-year-old and not achieving the age of retirement. However, she has suffered the short expectation of life. Thus, she should be emphasized to be awarded total damages for the support of her life. My lord, before I conclude my argument, does the court have any question?
If Dr. Kevin had made a proper diagnosis, how many percent of remission and how many percent of how many years of survival?
Approximately 40% of chance of remission and 10 years of survival.
Where do you get the facts?
Much obliged, my lord. Can if I would redirect the court to the mood problem in may I have a moment?
Page 2.
Indeed, my lord. In page 2, paragraph
7.
Paragraph 7, line second last line and the last line.
Okay, you may proceed.
Much obliged, my lord. In conclusion, my lord, there is a breach of duty by the first. My apologies, my lord. May I have some extension of time to conclude my submission?
Yeah. Okay.
Much obliged. In conclusion, my lord, there is a breach of duty by the first respondent in the delay of the referral regarding to the appellant disease. Besides, his action has caused the chain of causation, which has lowered the chance of remission and made her suffering the side effect of MS and lost her future earning. As such, the appellant submit that the of the standard between the failure to advise of the risk of the bladder cancer and the brain damage suffered by the appellant. Thus, the respondent can be liable for professional negligence. Thank you for your time and indulgence. My learned co-counsel, we will continue to submit on the remaining issues. Much obliged, and may it please this honorable court.
Thank you.
Much obliged.
May I proceed my submission, my lord?
Yes, please proceed.
Much obliged. Good morning. May it please this court. My name is Ahmad Asnawi and I will continue submitting on another 30 minutes for the next second issue. My lords, for the second issue, we submit that whether SMX Nila Medical Center has vicarious liability for the damage that the appellant suffered. My lord, before I submit the grounds for the second issue, do the courts have any question?
Please proceed.
Much obliged. My lord, we believe that there are three grounds to be submitted for the second issue. First, Dr. Kevin has a special relationship with SMX Nila Medical Center. Second, Dr. Kevin had committed a tortious act as a doctor. And third, SMX Nila Medical Center is bound by Dr. Kevin's tortious act. For the first ground, we submit that Dr. Kevin has a special relationship with SMX Nila Medical Center. My lord, the appellant submit that SMX Nila Medical Center is responsible for the negligence committed by Dr. Kevin because his action fulfill all the requirements of vicarious liability, which are Dr. Kevin and SMX Nila Medical Center has a special relationship. Dr. Kevin has committed the tortious act and SMX Nila Medical Center is bound by Dr. Kevin tortious act. Dr. Kevin and SMX Nila Medical Center have the employer-employee or master-servant relationship as he is an independent medical consultant at SMX Nila Medical Center. An employee is an individual that was hired by an employer to do a specific job based on his specific skills and was hired after he achieved the required level of knowledge and skill needed by the employer. Section 2 of the Employment Act 1955 defined both the employer-employee relationship as well as the term and condition under which employers can employ employees. The Act foresaw the old master-servant relationship, also which is the well-known contract of service relationship as the employment relationship. My lord, to enlighten the court that a doctor is an employee or a servant to the hospital where he treats his patient, may I bring the court the case of Dr. Wong Wai Ping and Woon Lin Sin, where the judge has decided that the negligence of the first defendant was vicariously liable to the organization based on the fact of the case. The second defendant had caused an injury to the plaintiff and had not exercised proper supervision and failed to explain that the child was delivered by forceps. The plaintiff claimed that the second defendant was an agent working for the first defendant. The plaintiff was asked to pay one bill for hospital charges. Also, the second defendant was assisted by the nurse who was a servant to the first defendant. This fact clearly shows that the second defendant was a servant of Pantai Medical Center, which is the first defendant. My lord, this case is related to Dr. Kevin and SMX Nila Medical Center, where Dr. Kevin is an employee to SMX Nila Medical Center as he made his appointment with the appellant there. My lord, The second ground under this issue is that Dr. Kevin had committed a tortious act as a doctor. Dr. Kevin failed to advise the appellant of the bladder cancer and brain damage risk, which proving that Dr. Kevin committed negligence under the duty of care as a doctor. There was a breach of duty when the defendant failed to exercise reasonable care and skills to our client to mitigate the risk of developing dangerous disease despite there was indecisive scientific evidence. My lord, based on Oxford Dictionary, one is to tell someone about something, especially something dangerous or unpleasant that is likely to happen so that they can avoid it. Regarding to the case of Ang Tiong Sang and Goh Wan Chir, the defendant did not apply a standard duty of care required, which he failed to warn and advise the appellant about her risk of developing cancer, which later causing her damage and had to sacrifice her work. My lord, the case that I brought up to the court just now is related to the tortious act committed by Dr. Kevin, as he failed to warn and advise our client about her disease, although Dr. Kevin was employed by SMX Nilai Medical Center to review a medical treatment towards an ill patient accordingly with a required specific level of knowledge and skills. My lord, before I move on to my third ground, do the bench have any question?
For the first point, is there any evidence or anywhere stated in the facts or mood problem or any contract to show that, to say that clearly and unequivocally that Dr. Kevin is an employee of SMX Nilai? Is there anywhere stated in any of the documents?
Much obliged, my lord. Much obliged, my lord. There is no evidence that stated in the problem that Dr. Kevin is an employee to SMX Nilai Medical Center. But indeed, I can say that Dr. Kevin is an employee to SMX Nilai Medical Center because may I bring the court the case of Su Cheng Ling and Dr. Kok Chong Sang and another appeal where the learned judge decided that a medical institution must ensure that doctors who practice in the institution are employed by them and have the necessary skill and competency to treat patients. My lord, to clarify, from the case I brought up earlier, say that the doctor who practice in an institution must be employed. So that I will say that Dr. Kevin is employed by SMX Nilai Medical Center to practice his necessary skill and knowledge.
How does the term independent medical consultant works here? If he is employed, how does independent medical consultant, why do you refer him to independent medical consultant then?
Much obliged, my lord. To answer your question, may I bring the court the case of Burisha Taranjit Kaur and another and Dr. Premita Damodaran and another, which define that the independent medical consultant is a medical practitioner. Did I assist your concern, my lord?
Okay.
Much obliged.
Please proceed.
Much obliged, my lord. Next, I will move on to the third ground, where my third ground is under the issue is that SMX Nilai Medical Center is bound by Dr. Kevin's tortious act. My lord, in vicarious liability, the employers are said to be vicariously liable for the torts committed by their employee during employment. Employers or masters may only be held liable for the torts committed by their workers or servant as they are referred to in the law. My lord, to clarify the court that the employee is responsible of the negligence committed by its employee, may I bring the court the case of Century Insurance Corporate Limited and Northern Ireland Road Transport Board, which has shown that the judges that held the employer is vicariously liable for his employee's negligence. My lord, may I also bring the court's attention to the case of Mat Jusuf bin Daud and Syarikat Seberang Jaya Takhir Sendirian Berhad, where the plaintiff injured himself in the course of employment, which caused him to lose 3 fingers of his right hand, and then the plaintiff sued the defendant. However, the defendant denied that the plaintiff was not their employee, as he was the employee of the defendant's contractor, Lim. On the fact of the case, Lim could not be held to be a contractor within the meaning of Section 19 of the Workmen Compensation Act, as he was not undertaking to execute any part of defendant's sawmill business. He was merely a middleman or agent to procure workmen for the defendant to be employed at the defendant's sawmill. The employer of the workmen must be the defendant of whose business they were employed. My lord, the document evidence in this case constitute a clear admission by the defendant that the plaintiff was their employee, and that this admission, despite the evidence given by the witness for the defendant, remained unrebutted. My lord, the case that I brought up to the court is related to Dr. Kevin when he had breached his duty of care as a doctor during his employment. Also, every employment attended by the appellant has happened at SMX Nila Medical Center, which make SMX Nila Medical Center is bound to Dr. Kevin's Tortious Act. Hence, SMX Nila Medical Center is also liable under vicarious liability towards the appellant due to his employee, Dr. Kevin, that already breached the duty of care within his working time. Is there any clarification needed by the bench before we conclude the overall submission, my lord?
You may conclude.
Much obliged. Therefore, my lord, we submit that there is a breach of duty by the first respondent, and SMX Nila Medical Center is liable in terms of vicarious liability which bound by the act of the first respondent. Also, we pray that the court is pleased with our submission and grants the relief prayed. If I am no further assistance to this court, that shall conclude my submission. Thank you for your time and indulgence. Much obliged.
Thank you. Okay, can proceed.
Much obliged. Good morning, my lord. May it please this honorable court, my name is Aina Christina binti Makfari, appearing as the senior counsel on the behalf of the respondent. And together with me, my learned co-counsel, Ms. Nurfati Nadia binti Johari. My lord, I will be submitting on the first issue for 18 minutes, while my learned co-counsel will be submitting on the second issue for another 80 minutes, and we will reserve 4 minutes for rebuttal. Before I begin with my submission, do my lord appreciate briefly summary facts of the case?
There's no need for you to summarize. You can proceed to your main point.
Much obliged. My lord, today in this honorable court, there are 2 issues of tortious liability need to be determined. The first issue is whether the trial judge was right in law in finding the respondent is not liable of a medical negligence, and the second issue is whether the delay of action made by the appellant amounting to contributory negligence, therefore maxim res ipsa loquitur applies. Therefore, with regards to the first issue, we argue that the trial judge was right in law in finding the respondents not liable of a medical negligence, since there was no sufficient causation between failure to advise and the damage suffered by the appellant, which was proven to factual causation and legal causation. To argue on this issue, I will divide my submission into 2 parts. First, I will argue that the respondent's conduct was not in fact caused the damage suffered by the appellant. Secondly, I will argue that the appellant's damage was too remote and is not recoverable in negligence. My lord, may I begin my submissions proper? Much obliged. My lord, as mentioned before, the first sub-argument for issue 1 is the respondent's conduct was not in fact caused the damage suffered by the appellant. On the first test, which is the but-for test, under the first sub-argument, we submit that the damage suffered by the appellant would have occurred even without the respondent's negligence. For the but-for test of causation, according to the case of Dr. K.S. Sivanathan and the government of Malaysia and another, the plaintiff would be unable to prove that the defendant's negligence causes damage unless he can show on a balance of probabilities that proper treatment will be resulted in his improvement or stop the deterioration. Thus, according to the case of Dr. K.S. Sivanathan, if the chance that proper treatment would have resulted in the desired outcome was less than 50%, the plaintiff had failed to prove that the harm would not have occurred in either case. Moreover, the High Court in Ang Yumeng and Dr. Sashikanan Anak Lelaki Arunasalam and others stated that the defendant's action was not a but-for reason if the harm would have happened anyway. Furthermore, in the Barnett and Chelsea, the plaintiff had failed to show on the balance of probabilities that the defendant's negligence resulted in the disease death. Moreover, the disease may have died even if all the precautions had been taken. In addition, the Court of Appeal in Hassan bin Datullah and Kerajaan Malaysia held that the appellant's paralysis which resulted from his injury was not due to the defendant's negligence in performing both operations. Thus, the defendant's negligence was not a but-for reason for the appellant's paralysis. My lord, in the current situation, the failure by our client, Dr. Kevin, to advise on the risk of bladder cancer and brain damage did not cause the damage suffered by the appellant, as the several symptoms of multiple sclerosis growing into bladder cancer was only detected when she was admitted to XYZ Hospital in August 2019, as stated in the mood problem paragraph 5, line 5. Moreover, even if our client has advised appellant on the risk, it would not have prevented the damage from occurring, as according to the expert evidence, with no delay in referral, the appellant would have had remission chance of approximately 40%, as stated in the mood problem paragraph 7, line 4. Hence, the probability that proper treatment by our client would have resulted in the desired outcome was less than 50%, which is lower. Thus, the appellant has failed to satisfy the burden of proof on causation, as it was more likely than not she would have developed bladder cancer and brain damage even in the absence of negligence by our client. My lord, if there is no question, may I proceed with the second test?
At paragraph 7, do you offer any evidence to contradict Dr. Azran's expert evidence in relation to the 40% and the 10 years chance of survival? Is there any evidence from Dr. Kevin to contradict this?
Much obliged, my lord. In assisting this court on the concern, we refer to the case of Dr. K.S. Sivanathan, where it is stated that if the chance that proper treatment would have resulted in the desired outcome was less than 50%, the plaintiff had failed to prove that the harm would not have occurred in either case. Hence, in this case, it is stated that according to the expert evidence, with no delay in referral, Amrita would have had remission chance of approximately 40%, which is less than 50%. So the balance of probabilities, is lower.
There is no evidence to rebut the expert evidence from your side. Is that right? So you accept it's 40%?
Indeed, my lord.
Okay, you may proceed.
Much obliged. My lord, on the second test, under the first sub-argument, we argue that the act of respondent did not materially contribute to the damage as there were multiple causes. According to the case of Bonington Castings Limited and Wardlaw, multiple causes refer to several causes not necessarily operating at the same time, and when they are, each contributes to the final damage. The House of Lords in Wiltshire and Essex Health Authority held that the combination of the defendant's negligence and the plaintiff's injury did not give rise to a presumption that the defendant materially contributed to the injury where it could be attributed to a variety of potential causes. Furthermore, in Hudson and East Berkshire Area Health Authority, the defendant was held not negligent because it was the accident itself that materially contributed to the plaintiff's disease, not the defendant's delayed treatment. Moreover, the High Court in Dr. K.S. Sibanathan and the Government of Malaysia in another held that the plaintiff through condition upon arrival at the hospital, which his leg was at a severe level of ischemia, the doctor could not be said to be negligent in delaying treatment at that stage, and it did not materially contribute to the cause of the amputated leg suffered by him. My lord, in the present case, our client's negligence in failing to advise on the risk of bladder cancer and brain damage did not materially contribute to the damage suffered by the appellant. Even if his negligence is considered as one of the causes of appellant's damage, it did not give rise to a presumption that he was the one who caused the damage. This is because one of the causes of the damage suffered by the appellant was her true condition when she first sought medical treatment with our client in October 2017, although the numbness was first manifested at least 9 months before, as stated in the mood problem paragraph 2, line 2 to 4. Furthermore, the appellant also continuously delaying her medical treatment even after she has been diagnosed with secondary progressive multiple sclerosis, as she stopped attending any medical treatment after 5 months consulting with our client, as stated in the problem, paragraph 3. Besides, it was the illness itself that caused the damage suffered by the appellant, as the several symptoms of disease growing into bladder cancer were only found out when she was admitted with serious bladder and bowel functions at XYZ Hospital, as stated in the mood problem paragraph 5. My lord, therefore, our client, Dr. Kevin, was not negligent because the failure to advise on the risk of bladder cancer and brain damage did not cause the resultant damage suffered by appellant, as it did not materially contribute to the damage. My lord, if there is any question before I proceed to the second ground.
Please proceed to the second ground.
Much obliged. Having finished with this first submission, I shall now move to the next submission concerning on the remoteness of the appellant's damage. On the second ground of the first issue, we will submit that the appellant's damage was too remote and is not recoverable in negligence. There is one sub-argument submitted, which is the damage suffered by the appellant is not reasonably foreseeable by the respondent. My lord, reasonable foresight test is on whether a reasonable man in the defendant's position would foresee the damage and the type of damage that has occurred to the plaintiff. As in Wagenmal number 1, the defendant was held not liable for the consequences of his wrongdoing that was not reasonably foreseeable. Furthermore, in Tremains and Pye and another, the defendants were held not liable as they could not foresee the plaintiff might be exposed to the Wales disease, which is a rare disease in their country. Hence, the damage suffered by the plaintiff was unforeseeable and too remote to be recoverable. In addition, the High Court in Zulhasnimar binti Hassan Basri and others, and Dr. Pupu and Valmani P and others relied on the expert evidence that confirmed the condition of the placenta, which called placenta picrata, was a rare condition and it cannot be detected even with advanced imaging techniques. Thus, it was impossible for the defendant to foresee the implications. My lord, in the current case, it is impossible for our client to foresee and further give advice about the risk and damage of multiple sclerosis that will be suffered by the appellant, as the bladder cancer and the brain damage are not laid down as the common symptoms of multiple sclerosis, according to which are the common symptoms of multiple sclerosis, which are fatigue, weakness, depression, shaking, and loss of coordination, memory changes, numbness and tingling, double vision, bladder problem, visual loss, unsteadiness, and dizziness. Moreover, the World Health Organization reported that the Asian descendants are at the lowest risk of developing multiple sclerosis, which approximately third. The multiple sclerosis is a serious disease among Asians. Besides, the diagnosis and treatment of sclerosis usually conducted by it is possible for an independent medical consultant like our client to have the same level of skills and knowledge equivalent to a neurologist and to foresee the further risk and damage of multiple sclerosis. Hence, the appellant's damage was too remote and is not recoverable in negligence, as the damage suffered by the appellant is not reasonably foreseeable by the respondent. My lord, is there any clarification needed by the bench?
So even if Dr. Kevin conducted all tests at the time, it is, are you saying that it is still not foreseeable?
Thank you for addressing, thank you for the court's concern. In assisting the court upon this matter, Dr. Kevin had fulfilled his duty of care whereby he had acted based on the available medical evidence, as he had diagnosed the appellant as having the secondary progressive multiple sclerosis when she asked about the numbness. Also, Dr. Kevin had set up the medical appointments with the appellant and have consultation with her. And the numbness asked by the appellant was a common symptoms of multiple sclerosis. Therefore, Dr. Kevin did not foresee the damage suffered by the appellant, as the numbness was a common symptoms of multiple sclerosis. Am I addressing the court's concern?
Thank you. Please proceed.
Much obliged. My lord, based on the foregoing reasons, the respondents respectfully request this honorable court to adjudge and declare that the trial judge was right in law in finding the respondents not liable of medical negligence, since there was no sufficient causation between the failure to advise and the damage suffered by the appellant, which was proven through factual causation and legal causation. As such, the respondent's conduct was not in fact caused the damage suffered by the appellant, and the appellant's damage was too remote and is not recoverable in negligence. My lord, is there any clarification needed by the bench before my learned co-counsel continues submitting the next issue?
Nothing from me. Thank
Much
you.
obliged. My learned co-counsel will continue to submit on the remaining issues. May it please this honorable court.
May I begin, my lord?
Yes, please proceed.
Much obliged. Good morning. May it please this honorable court, my name is Nurfati Nadia, and I will continue submitting the next issue. I propose to take 18 minutes of this honorable court to address the issue. My lord, with regards to the second issue, we submit that the delay of action made by the appellant amounting to contributory negligence, therefore, maxim res ipsa loquitur applies. My lord, in order to show that the delay of action made by the appellant amounting to contributory negligence and therefore maxim res ipsa loquitur applies, there are two grounds to be submitted, which is first ground, the appellant has fulfilled the elements of contributory negligence as her delay of action contribute to the damage that she suffered. And for the second ground, we submit that as maxim res ipsa loquitur applies, the burden has shifted to the respondent in proving no negligence on his part. My lord, may I begin my submissions proper? Much obliged. For the first ground, whereby the appellant has fulfilled the elements of contributory negligence, as her delay of action contribute to the damage that she suffered, the appellant has fulfilled two elements under this ground, whereby the first element, the appellant has failed to take reasonable care of herself by behaving unreasonably in avoiding damage. For the definition of the contributory negligence, my lord, we submit that in the case of Taranjit Singh, son of Bhagwan Singh, and another, and Dr. Premita Damodaran and another, the High Court in this case stated that contributory negligence means that the plaintiff has failed to use reasonable care for his own safety. Moreover, we also refer to Section 12, subsection 1 of the Civil Law Act 1956, which stated that when the plaintiff has failed to use reasonable care of his own safety, it is partly resulted to his own damage. My
For
lord.
the case that you have just cited, is it stated anywhere in your submission?
Yes, my lord. In the enclosure 25.
Thank
May I
you.
proceed, my lord?
Yes.
Right, so much. In proving that the appellant has failed to take reasonable care of herself by behaving unreasonably, we refer to the decision of High Court in Hassan bin Datola's case, whereby in this case, the court held that the appellant's damage was not caused by the operation that conducted by the doctor, but was a complication of his injury as a result of his delay in seeking treatment. Moreover, my lord, we also refer to the decision of the High Court in Ahmad Takif Amza bin Ahmad Huzairi and Kuala Terengganu Specialist Hospital Sendian Berhad and others, whereby the court in this case held that the delay on the part of the plaintiff's parent to bring plaintiff to the hospital was unreasonable and had contributed to the increasing of the injury that suffered by the plaintiff. Therefore, my lord, to relate to the case at hand, we submit that the delay by appellant in seeking medical treatment whereby it's stated in the paragraph 1 problem that the appellant only sought medical treatment when the symptom first manifest itself 9 months before she made an appointment with our client. And this, my lord, indicates her failure to take reasonable care of herself. And also, as stated in the problem, paragraph 3, she also did not attend any medical treatment after 5 months consulting with our client, even after she has been diagnosed with secondary progressive multiple sclerosis. Furthermore, appellant has also failed to take reasonable care of herself by behaving unreasonably when she was continuously delaying her treatment. Firstly, as mentioned in the paragraph 4 in the problem, my lord, when she stopped seeing first respondent as in January 2019, she moved to Sandakan for her husband's work transfer. And secondly, she failed to take reasonable care, whereby when about a year consulting with our client, only then the appellant sought another medical treatment with another doctor, which is Dr. Hans, as mentioned in problem paragraph 4. Hence, my lord, the deterioration of appellant's condition was not caused by the delay of referral by our client, but it is because of her unreasonable delay in seeking treatment. My lord, it is proven that she has failed to take reasonable care of herself as a person would when suffering multiple sclerosis. Is there any clarification needed by the bench before I proceed to the next element?
Please proceed.
Much obliged. For the second element that has been fulfilled by the appellant under this first ground, whereby the appellant's damage is reasonably foreseeable from her act or omission. Under the definition of this element, we refer to the statement from the High Court in Taranjit Singh case, whereby the court mentioned that contributory negligence is depending on whether the claimant ought to have reasonably foreseen the harm to himself if he failed to take reasonable care of himself. My lord, in proving the appellant's damage is reasonably foreseeable from her act or omission, we refer to the case Quack Hobolt and Lee Sin Quing, whereby this case is distinguished facts with our case at hand, that the principle in this case is similar in our case at hand, whereby the plaintiff in this case was contribute toward his own discomfiture, as he ought to reasonably foresee that if he was not drive at a safer distance and speed behind the taxi, the collision between them would happen when the taxi was stopped. And we also refer to the case of Johns and Levox, whereby the Court of Appeal in this case stated that the plaintiff did contribute to his injury when he climbs and read upon the back of truck excavator, even though he knew and reasonably foresaw that such conduct was dangerous. This case also have the distinguished fact with the case at hand, but the principle is once again similar in the case at hand. Hence, my lord, in the case at hand, whereby the appellant has contributed towards the deterioration of her health condition, where she ought to reasonably foresee the damage that she could suffer when she failed to take reasonable care of herself, which she was delaying her medical treatment from the beginning, whereby from the symptom first manifests itself 9 months before she consult with our client, as stated in the moot problem, paragraph 2. And she also continuously delayed the medical treatment, whereby 5 months after consulting with our client, the appellant did not attend any medical treatment, and also about a year after consult with our client, only then she sought medical treatment with another doctor in Sandakan, as stated by the paragraph 4 in the problem. Beside, my lord, considering the appellant age and gender, which is 45 years old lady, she is more vulnerably exposed to the disease. Therefore, she ought to reasonably foresaw that if she failed to behave as a reasonable person who's having multiple sclerosis, wish to seek for medical treatment earlier, she could suffer damage, as stated in paragraph 4. No problem. Considering the age and gender of the appellant, she is more vulnerably exposed to the disease. And also to support this statement, we refer to the statement by neurologists who are expert in the multiple sclerosis disease that stated the average of onset multiple sclerosis is when people are in their 40s and 50s. So by looking at the age of the appellant, who is a 45 years old lady, we submit that she is indeed under the category of risk people to suffer multiple sclerosis. Therefore, she should take reasonable care.
Where do you
of
find
herself
the evidence of the neurological evidence on this?
Thank you for pointing that out, my lord. We refer to the book Understanding Progression in Multiple Sclerosis that produced by Multiple Sclerosis Association of America in 2017. Am I addressing this concern?
Where does it stated in your submission?
Much apology, my lord. It does not state it in our submission. It's additional.
Please proceed.
May I press? Much obliged. Thus, my lord, it is submitted that Amrita or the appellant is liable of contributory negligence, as she did contribute to the deterioration of her health condition due to her continuously delay in seeking medical treatment. Is there any clarification needed by the bench before I proceed to the next
Please
round?
proceed.
Nice job, class. For the next ground that we submit, which is maximum reciprocal locator applies, the burden has shifted to the respondent, improving no negligence on his part. In order to prove that, prove this ground, we refer to the case Cassidy and Ministry of Health, whereby the Court of Appeal stated in this case the maximum reciprocal applied in this case. Therefore, the onus laid on the hospital authority on behalf of the respondent to prove that there had been no negligence on their part. Moreover, my lord, we also refer to the case of Wong Chun Mei and another, and Dr. Kuldeep Singh and another, whereby the Supreme Court in this case held that even if the maxim applied against the defendant, he may rebut it by justifying that he was not negligent. Hence, my lord, this shows that once the maxim applied, the burden has shifted to the respondent, in our case, improving no negligence on his part.
Do you have the facts of the case that you have cited, Wong Chun Mei and Dr. Kuldeep Singh?
Thank you for pointing that out, my lord. May I be given a moment? Much obliged. in addressing this court's concern, the fact of the case that we delivered just now, Wang Chun Mei, the plaintiff in this case is suffered rib fracture that are noticed by the doctor, which caused internal bleeding towards the plaintiff, and the result of that, the plaintiff died. Am I addressing this court's concern?
Please proceed.
Much obliged. Furthermore, we also refer to the case Liu Xin Kiong and Dr. Sharon D. Ampol Raj, whereby the High Court in this case held that even if the prima facie of negligence had proved under the maxim against the defendant, she had rebutted it by demonstrating that she has acted in accordance with this accepted practice. Thus, the defendant has successfully proved that she was not negligent. Therefore, my lord, by referring to the case at hand, the maxim has successfully invoked by the appellant as stated in the paragraph 10b problem page 3. Thus, the burden to prove no negligence has been shifted to our client, as our client as an independent medical consultant was not negligent, as there is no sufficient accusation to prove the negligence as stated by my senior counsel just now, and also our client has carried out his duty based on the available medical evidence, whereby she diagnosed Amrita as having secondary progressive multiple sclerosis as stated in the clarification under paragraph 3, number 4. Therefore, my lord, it is proven that our client has successfully discharged the burden of proof that was shifted on him by proving there had been no negligence on his part in treating appellant as his patient. Is there any clarification needed before I conclude the overall submission?
Please conclude.
Much obliged. Therefore, my lord, we submit that based on the foregoing reasons, the respondent respectfully requests this honorable court to adjudge and declare that the trial judge was right in law in finding the respondent not liable for medical negligence, and also the delay of action made by the appellant amounting to contributory negligence. Therefore, maxim res ipsa loquitur applies. If I am of no further assistance to this court, that shall conclude my submission. Thank you for your time and indulgence.
Thank you. Thank you very much.
Much.
Okay. Can we proceed?
My lord, may I begin my rebuttal?
Yes, please proceed.
Much obliged. My lord, the appellant has 2 points to be made in this rebuttal session. The respondent, my first rebuttal is the respondent contended that the failure of Dr. Kevin to advise on risk of bladder cancer and brain damage did not cause the damage suffered by Amrita. They also claim that the several symptoms of multiple sclerosis growing into bladder cancer was only detected when she was admitted to XYZ Hospital in August 2019. Therefore, the appellant submit that the failure by Dr. Kevin to warn on the risk of bladder cancer and brain damage is the initial cause for the appellant to suffer the effect of the MS. I will say that the bladder cancer and brain damage are not the symptom, but the side effect that develops in line with seriousness of the MS. Thus, I would say that Dr. Kevin's act for not warning on the risk of bladder cancer and brain damage to develop prove him liable for the appellant's damage, not the XYZ hospital. My second rebuttal is the respondent submit.
Your first rebuttal, you say that it's more of a side effect instead of a symptom. Is there any evidence to support your argument on this?
Much obliged, my lord. Indeed, in the medical, I have searching in the internet, there are medical studies that said the risk of the multiple sclerosis is the bladder cancer and also the brain damage. Am I correct address?
Is it a reliable source from the internet, or is it a medical journal?
It is it is stated from a medical author.
Please proceed.
Much obliged. My second rebuttal is the respondent submit that our client has neglected a duty of care and put further concern on her disease. They also claim that our client has not acted reasonably as she is delaying the treatment and not taking it seriously. We want to clarify that the respondent failed to give advice about our client's disease in the first place. If the respondent did advise our client during her first appointment, we are sure that our client will attend and never miss the next appointment and take a cautious step to take care of herself. I think that will end my submission for today. Much obliged, and may it please the honorable court.
Is there any evidence to say or anything to say that why did she miss the appointment?
Much obliged, my lord. Can I have a moment? Indeed, my lord, in the mood problem, they are not stated that Amrita as the reason that Amrita not attending the treatment, especially after 5 months of the diagnosis. However, if my lord, may I extension time?
Yes.
Much obliged. However, if I could redirect the court to the